Your Honor, I'm here today to appeal a decision made in my client Perry Davis's court case. On May 17th, 2007, my client was wrongfully accused of harboring a person wanted for questioning and charged with concealing narcotics in his home. On May 17th, the police were denied entry to the home of Mr. Davis. The police then contacted headquarters, where they were told to stand by until further notice and watch him. Not long after this, the police approached my client's house again with an alleged search warrant. The police knocked on Mr. Davis's door, and Mr. Davis's 11-year-old son, Sean, answered. The police then showed Sean a piece of paper that was supposed to be the search warrant, and being a kid like he is, he allowed the police to come in. My first major point is that the police used Sean's innocence to gain entry into the house. Sean's dad was home the entire time, but they still used the conditioned Sean to gain access to the interior of the home. Sean, like many kids, has been conditioned to listen to figures of authority, especially if they're his parents, teachers, or cops. After the police entered the home, Mr. Davis attempted to view the search warrant, but which he was denied access to. That's pretty suspicious, right? The police searched the house and eventually made it to the bedroom. In the bedroom, the police found a bag, which they thought was cocaine. My client, Mr. Davis, claimed that it was the previous tenant's, but he was booked on the charges of possession and concealment anyways. We went to court not long after this, and the judge's ruling was a sentence of 1 to 7 years in prison on the charge of possession of an illegal substance. Ladies and gentlemen of the court, that alleged search warrant that the police used to trick Sean was never signed by a judge to begin with, invalidating the warrant to search the house. Not only this, but the police entered the home on a minor's allowance, despite an of-age homeowner being present the entire time. This the police knew. I believe that the police used the innocence of Mr. Davis's 11-year-old son to gain entry into the house. There was no good faith in this encounter. Not only this, but I believe that it was an ill-will attempt for the police officers to gain spotlight by busting a case wide open. They shouldn't have been in the house to begin with, which is my second point. The fact that the warrant was never signed makes the charges, and especially the circumstantial evidence brought up in my client's previous trial, inadmissible due to the lack of the valid search warrant. Despite this, the trial and booking went on anyways. Your Honor, this is a violation of the Fourth Amendment and the Bill of Rights of the Constitution. I ask you to overturn my client's ruling, ensuring and protecting the validity of our great Constitution. Thank you.
Hello, my name is Mercedes. I will be representing the lawyer for the prosecution side and will be giving factual reasons as to why the conviction should be upheld. Mr. Davis's conviction should be upheld because the police were acting on good faith after the judge affirmed the search and seizure. Though the warrant did not reflect the authorization through a signature, the judge did testify that they reviewed the affidavit, found the probable cause to be valid enough to approve the search warrant. They testified to having full intentions to sign the warrant. Therefore, the judge authorized the search warrant. To begin, I will address the issue of the child allowing entry into the Davis's home. The child giving consent to enter the home is moot. The police officers were acting on good faith after the judge authorized the search and seizure. Here's why. It is true that a child can only give consent to police to enter their home if a guardian is not present. Yes, Mr. Davis was in fact inside the home at the time that the police executed the warrant, but the police officers knew that they did not need the child's permission nor Mr. Davis's consent because they already obtained, as far as they know, a valid search warrant. Once a search warrant is obtained and authorized by the judge, the consent of the owner of the property is moot. Therefore, none of their permissions were needed. That reasoning stands because the officers were acting on good faith. As far as the officers knew, they did have a valid warrant. The judge authorized the search and seizure. Now my argument will begin as to why the warrant itself is justified. Today's case is all about our great Constitution's Fourth Amendment. In order to know how to protect your civil liberties, you must know what they are. Therefore, the Fourth Amendment reads as follows: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause that is supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Those three things must be present in our situation in order for the search to be justified. So, number one, probable cause. As I mentioned previously, the judge reviewed the affidavit, which provided enough facts to build probable cause. We know this because the judge testified to approving the warrant, meaning they agreed that there was enough probable cause to exercise a search and seizure. Number two, supported by oath or affirmation. The probable cause is valid once oath or affirmation is established in saying so. Recall our previous point in probable cause. The judge testified to authorizing the warrant. That testimony reflects the judge's affirmation of the probable cause stated in the warrant. Therefore, the second requirement is justified. Finally, number three, describing the place to be searched and the person or things to be seized. If you review the warrant, you'll see those exact descriptions, locations, and names listed. All in all, the warrant included those three requirements. Therefore, the search and seizure is justified. To close out, Mr. Davis's conviction should absolutely be upheld. No search and seizure is allowed until affirmation of probable cause is obtained by the judge. The defendant's claim of a violation to his Fourth Amendment rights are not a valid reason to turn over his conviction. Why? Because there was no violation of his Fourth Amendment rights. The Fourth Amendment does not state a signature is required for a search warrant to be issued. The Fourth Amendment requires probable cause affirmed by a judge stating the place to be searched and the person or things to be seized, which I have proved in my previous explanation. Our police officers acted on a search authorization that included all three of those requirements. Their actions were not a violation of anyone's rights or liberties. Mr. Davis's conviction is justified.
After reviewing the evidence and the arguments from the defense and the prosecution, we have come to a decision.
Mr. Perry Davis, the search, seizure, and arrest of him was unconstitutional, and we wish to grant an appeal. Amendment 4, Section 6 defines unreasonable searches and seizures. This search was unreasonable due to a search without authority from a magistrate or a judge. There was no signature present, and therefore the warrant is null.
Along with the fact that the probable cause given was dubious at best, as well as the simple legal fact that a minor cannot consent, period.
Mr. Davis Perry was also never presented a warrant. His child was presented, again, the unsigned warrant, but therefore the homeowner, the individual who's above 18, was never presented the warrant, and the warrant was never specified to being a no-knock warrant. Therefore, the other party needed to be aware of the warrant being executed. And also, the Fourth Amendment goes into talking about the Fourth Amendment also clarifies that if there is more than one co-owner in a household or more than one individual present in a household, they have to have a unanimous agreement for a search unless a valid warrant is presented. Now, the child, again, as he said, was underage. He could not legally consent. But Mr. Davis Perry, he could have said no. The officers were aware of his presence in the home, but decided to use the minor child for access.
And therefore, we shall be granting Perry Davis an appeal.